If you've recently been informed that you're not meeting the expectations of your role and you're being placed on a performance improvement plan, you're probably worried about what's next. This is a stressful thing, and it's completely normal to feel anxious, confused, or even blindsided. You probably have a lot of questions running through your mind right now. Hi, I'm Mike with Cashion Legal, and I want to help you understand what it means if you've been placed on a performance improvement plan. At the end of this video, you'll have a better understanding about what it means if you're being placed on a performance improvement plan, what the legal implications are of this situation, and what options you might have before you. By watching this video, you'll have a clearer picture of where you stand and what to do next. Let's get started with the most common question we get about performance improvement plans. The first thing that people almost always ask us about being placed on a performance improvement plan is whether or not this means they are going to be fired. The honest answer is not necessarily. A performance improvement plan, also known as a PIP, does not automatically mean termination of employment. Some employers will use a PIP as a genuine attempt to work through a performance issue. When used properly, it can be a helpful tool that gives employees a clear path forward to resolving a workplace concern. Having said that, there are some cases where a PIP is not legitimate, and it's really just an employer trying to build a paper trail to later support termination of employment. So this begs the question, how do you know which situation you are facing? To help you better understand your circumstances, I'm going to run through 3 common red flags we see with illegitimate performance improvement plans. The first red flag we see with an improper performance improvement plan is where it imposes vague or unmeasurable standards. A proper PIP requires clear objective standards, things you can actually measure and achieve. If your PIP imposes requirements that you do things like demonstrate better judgment or use better communication, these are vague, unobjective standards that cannot be easily measured. In fact, it's almost impossible to assess these things on an objective basis. This vague language can be a sign that your employer is not actually trying to help you improve, but is just trying to set you up for termination at a later date. The second red flag that we see with improper PIPs is where the criticism is not actually related to your role. PIP should focus on your actual job responsibilities. It shouldn't raise criticisms for things that are beyond the scope of your role. If a PIP raises concerns about things that were never part of your job, this is a serious concern. This kind of overreach can suggest that your employer is trying to cast a wide net to build a case against you, rather than actually support you in your job performance. The third red flag that we commonly see with PIPs is where they don't provide the employee with an opportunity to improve. Legitimate PIP has to give you a meaningful chance to address your job performance. This means a realistic timeline for addressing your employer's concerns, along with actual support from your employer. If the timeline provided in the PIP is unrealistically short, or if your employer isn't providing you with any actual support throughout the performance improvement process, this also suggests that the PIP is actually just trying to set you up for termination at a later date. So those are 3 signs that we see where a PIP is being imposed simply to set an employee up for termination later on. And if any one of these circumstances applies to your situation, I strongly recommend that you seek legal advice with respect to your PIP. Conversely, those 3 factors also identify what a proper PIP looks like. A legitimate PIP will have clear objective standards, be actually related to your role, and provide a clear timeline with actual support from the employer in order for you to address the employer's concerns. Another common question that we get from clients who have been placed on performance improvement plans are, what are the legal consequences of the situation? Broadly speaking, there are 3 distinct outcomes that can arise if you've been placed on a PIP. The first situation that I'd like to discuss is termination without cause. If your employer has made a legitimate attempt to address your performance, but you haven't satisfied the expectations following the performance improvement plan, your employer may terminate your employment without cause at the end of that process. If your employer is terminating your employment without cause, this means that you will either receive notice of termination or pay in lieu of notice, which we commonly refer to as severance. It is worth noting that your employer is permitted to terminate your employment without cause, even if you think you satisfied the objectives of the PIP. Because they are providing you with either notice or pay in lieu of notice in connection with this termination, your employer does not have to prove that termination was justified in the circumstances. So even if you satisfied the requirements of the PIP, your employer still has the ability to let you go at the end of that process. The second possible outcome of a PIP is a much more drastic situation, which is termination with cause. If your employer terminates your employment with cause, this means that you won't receive any advance notice or any severance. Because termination with cause is such a drastic remedy, employers have to meet a very high bar in order to do this. In the context of termination following a performance improvement plan, the employer will need to prove that it was clearly communicated to you that you were not meeting the expectations of your role, what the expectations you needed to meet moving forward were, and that failure to meet these expectations would result in the termination of your employment. If your employer cannot satisfy those things, it's unlikely that they will be able to terminate your employment with cause. The third possible consequence of a performance improvement plan is a constructive dismissal. This is somewhat different from the other two outcomes because this would occur if you do not feel the PIP that's being imposed is fair. Unlike the other two situations, in this scenario, you would not have adhered to the performance improvement plan, but you would have objected to it in the first instance. This can occur if the PIP was illegitimate and aligned with one of the examples I explained earlier in this video. In this situation, you would object to the performance improvement plan once it was communicated to you by your employer. If your employer insists on implementing the performance improvement plan, instead of following through with the plan, you would resign from your employment and treat yourself as having been dismissed. We have a more comprehensive video dealing with the concept of constructive dismissal, which I will link in the description to this video. I do want to add that constructive dismissal is a very serious remedy, and we only recommend that people pursue this remedy with the benefit of legal advice. Now that we've covered some of the legal consequences of the situation that you're facing, let's talk about how you should respond if you've been presented with a performance improvement plan. Well, this is a situation where it's never a bad idea to get legal advice, which you can do by clicking the link to our website in the description of this video. Here are 3 basic tips that I can provide to you if you've been provided with a PIP. Tip number 1 is don't sign the document right away. If your employer presents you with a PIP, you are under no obligation to immediately execute the document. You are entitled to take it away, review it carefully, and consider or not whether you agree with the contents of the document. Which brings me to tip number 2, which is to read and understand what the PIP is communicating. When reviewing the PIP, you should consider some of the red flags that I raised earlier in this video, like whether it includes vague expectations or whether the criticisms relate to your actual role. Most importantly, if you disagree with the contents of the PIP in any way, you are within your right to request changes to the PIP or the criticisms therein to your employer. If any of these red flags are present, you may want to push back on your employer about signing the PIP before these concerns are addressed. Additionally, if you just plainly disagree with the contents of the PIP, you probably shouldn't sign it before that's communicated to the employer. The third piece of advice I have with respect to performance improvement plans is to consider whether there's any available compromise between you and your employer. If you disagree with the contents of the PIP, but you still want to remain with the company, there may be a possible middle ground for you and your employer. If you feel comfortable having this discussion with your employer, it's never a bad idea to explore this option. The bottom line is that a performance improvement plan does not necessarily mean the end of your employment. It might be that your employer is implementing the plan because they want to make a legitimate effort to work through a performance issue. In the alternative, if you have any concerns about the PIP or you notice any red flags that suggest the employer might just be trying to set you up for termination, you do have options in this situation as well. At Cashion Legal, we help employees who've been placed on performance improvement plans by providing them with clarity about their situations, strategies for responding, and peace of mind through sound advice and strong representation. If you find yourself in this situation, we would love to help you. Just click the link to our website in the description to this video and book a consultation with our office today.